Mark Meadows files an emergency motion to stop Big Fani. She's trying to make that arrest happen. If he doesn't turn himself in by Big Fani's deadline, well, she's just going to issue warrants. There was a series of exchanges in emails between Mark Meadows' defense team and Big Fani Willis. We know that Mark Meadows is already trying to remove this case. He's filed a notice of removal. The judge has scheduled this for a hearing, and so the judge ultimately can decide what to do with the removal, whether it will stay with the federal court outside of Fani's state jurisdiction, or whether it's going to go back down to the state court. But that is still pending. That's all a parallel track that's taking place right now. Big Fani says, I don't really care what's happening in federal court. In my court, where I think this case is, until the judge says otherwise, you're due here for your indictment. And if you're not here, I'm going to consider you to be away without leave, failure to appear, and I'm going to issue an arrest warrant. So they said, well, Big Fani, we don't think you do have jurisdiction. So we're going to talk to the federal court about it. And there was a back and forth. Now, here are the emails from Mark Meadows and his team over to Big Fani Willis. He says, all right, from John Moran, Philly to Fani Willis, the biggest Fani in all of Georgia. I still, to this day, have not found a bigger Fani in Georgia. If anybody knows of one, let me know. Miss Willis, Fani, on behalf of our client, Mark Meadows, wanted to reach out to see if you or an appropriate representative from your team would be available for a call this afternoon. Yesterday, Mr. Meadows removed the criminal proceeding that your office initiated against him to the federal district court. Court's already docketed it, but I'm sending it a copy to you for your convenience. John says, we intend, Big Fani, to move promptly to determine the removal and should be permitted to notify the state court pursuant to the law. We would welcome the opportunity to confer with you on the motion, including a particular. I should also note, we would welcome the opportunity and otherwise to wait for Monday morning, right? Welcome an opportunity to confer about those issues, but we'll otherwise wait till Monday morning. All right. So these are the types of emails that are being sent. There's a back and forth that goes on, and ultimately they need more time. So after a series of exchange, we fast forward through all of that. Okay. And now we see this email that came out from Fani on Tuesday, August 22nd. They're having this back and forth. We need more time. From Fani. Good morning, Mr. Moran. I am not granting any extensions. I gave 2 weeks for people to surrender themselves to the court. Your client is no different than any other criminal defendant in this jurisdiction, which obviously we know is total nonsense. They keep repeating that, but it's not true because Trump is treated very differently. For example, they gave him a $200,000 consent bond. That's strange. A lot of other people who are charged with very similar crimes are held without custody, without bail, in custody. So Fani says, 2 weeks was a tremendous courtesy. At 12:30 p.m. on Friday, if you're not here, if your butt's not here, Mark, I shall file warrants in the system. My team has availability to discuss reasonable consent bonds Wednesday and Thursday. So Mark's and his team, right? They're not even wanting this consent bond. They're saying, no, there's no bond. We're not self-surrendering. You don't even have this case. Yours in service for the Democrats. Fani T. Willis, biggest Fani in Georgia. Now, I don't know why she should put that in her signature. There is no bigger Fani than the district attorney for the Atlanta Judicial Circuit out of Fulton County, Georgia. So, yeah. Anyways, all right. So that's Big Fani. Now, this is another letter. Said, all right, well, here's another letter on behalf of our client, and this was the letter attached. We're also going to send a hard copy. That was the one saying no extension. So she says, nope, don't even think about it. Warrants if you're not here. And they say, well, obviously that's not something that we're interested in doing. We're not going to show up there. You don't have jurisdiction over us. And so what did they do? They filed an emergency request. They said, all right, well, if you're going to issue an arrest warrant, we're going to go talk to the federal judge about this. 3-page filing in the Northern District of Georgia. This is the federal district court. It's the Mark Meadows case. This is the declaration. So let's come back to that. This is the emergency motion. This is a 19-page filing from Mark Meadows. He's saying, we need some help, Judge. Emergency motion for the immediate removal and or for an order prohibiting DA Big Fani Willis from arresting defendant Mark Meadows. Do not let her conduct this arrest. Judge says, or Mark Meadows' defense says, Your Honor, Mark Meadows moves this court promptly to permit removal and notify the state court without a hearing. I know we're scheduled for a hearing, but we need this case removed before noon on August 25th because Fani is threatening to arrest my client. We've got to protect Meadows from an arrest prior to this upcoming hearing on the removal. Granting removal immediately and notifying the state court is the most efficient way to effectuate relief. Federal courts have permitted removal without first holding evidentiary hearings. There's some case law to support that claim. Now, if you don't do this, if you don't remove this immediately, Your Honor, alternatively, the court can grant relief by issuing an order that Big Fani Willis, the biggest Fanny in Fulton County, who is a party to the matter before the court, you issue an order to her prohibiting her from arresting or causing the arrest of Mr. Meadows before the Monday hearing. So Meadows is going to make his arguments in front of the judge on Monday. Fani says your deadline is Friday. And if you are not in my jurisdiction, self-surrendered with a consent bond, there's going to be a warrant for your arrest. And then what's he going to do? Show up on Monday in federal court with a warrant? Meadows says immediate relief is necessary. District Attorney Big Fani has made clear that she intends to arrest Mr. Meadows before this court's Monday hearing and has rejected out of hand a reasonable request to defer one business day. Just move it one day until after this court's hearing. Of course not, because no one's above the law. Ugh. Absent this court's intervention, federal judge, Mr. Meadows is going to be denied protection from the arrest that federal law affords federal officials. This is why we have this federal supremacy stuff, so that little partisan hack state prosecutors can't do this stuff. That's why this court's prompt but orderly consideration of removal will be frustrated. He filed immediately, and remember, Mark has been like rapid speed for this reason, because he knew that there was going to be a deadline coming up, and he's not showing up with a consent bond and posting money for a crime that he didn't do. So he's saying, Judge, you've got jurisdiction, and the law provides me with immediate right to removal. And now she's trying to frustrate that because you set a hearing. So in other words, she's trying to undermine your efforts, Your Honor. Says, Judge, let's just remember this. The Supremacy Clause protects federal officials from being arrested. Okay, that's the quote in bold. And being brought to trial in state court. That's from a Supreme Court case in 1880. Not just being convicted and sentenced, right? It's also the arrest. It's not just the later parts of this, which is a conviction and a sentence. It's what starts the whole thing off. Congress has also said that when cases are removed federally, the state proceedings must be halted immediately if the case is civil and after prompt consideration if the case is criminal. Mark Meadows says, I've been very prompt, Judge. We've moved quickly as possible to remove the case. Consistent with this, and this court has acted promptly. On Wednesday, August 16th, the court entered an order holding that the notice of removal is sufficient to withstand summary remand and set this for a hearing on Monday, the 28th. Earlier that day, Meadows' lawyers had made efforts to meet and confer with Fani about this removal. But they, at Fani's office, informed the lawyers that no one from the DA's office would be available until Monday, August 21st, right? So they file it the 16th. It's going to take them a while to get back. Well, of course they wanted to delay. So that Mark has no choice but to show up for their deadline. At 10:30 a.m., Monday, August 21st, defense finally spoke with Big Fani's office, and they informed counsel of their firm terms for a consent bond. Fani said, nope, Meadows would be arrested if he does not voluntarily appear before noon Friday, August 25th, even though the federal court has set a hearing to determine whether removal is warranted or not on that following Monday. On the afternoon of that Monday, counsel for Meadows sent Big Fani a request of a modest extension, not long at all, noting that this court set a hearing for Monday. They said, well, it would be eminently reasonable for Mark Meadows to surrender next week after the hearing in federal court. Counsel further stated that if DA Willis agreed to additional time, that we could meet and confer and we could do this promptly, quickly in Fulton County. But this morning, Big Fani said the following: I'm not granting any extensions. I gave 2 weeks for people to surrender. Your client's no different than anybody else. Rah! Counsel responded earlier and said, yeah, guess what? Mark Meadows is different than other county defendants. Why? He's a former federal official. Other people are not. The laws are different from former federal officials, just like the laws are different for, let's say, police officers or prosecutors or other federal officials that get alleged to have committed some sort of malfeasance. He has a pending notice of removal. Other people don't have those same claims. Now, Fani doesn't care about that. The court says Meadows and his defense should promptly grant relief to prevent Meadows from irreparably losing his right under federal law to be free from state prosecutor hacks who try to make arrests. Some other courts have allowed this before without having a hearing. When it's efficient and effective, sometimes courts should do it. They cite some law. They say a defendant can remove the federal case if the following 2 things are met. We've talked a lot about this. You see, when we see all these italics and parentheses, this is authority. So just to highlight some of these, we've got Supreme Court case here, Jefferson. We've got another United States Constitution's a good one. Here's another one, United States 1890 Supreme Court, 11th Circuit 2009, another 11th Circuit here, another 11th Circuit. They say, look, that is enough, okay? Mr. Meadows need not win his case before he can have it removed. He doesn't have to go to trial and secure victory. The standard for removal, Judge, is even easier to meet than the standard for asserting the Supremacy Clause immunity on the merits. Prompt action is needed needed to spare Meadows the cost of defending himself in state court, which is the exact reason we have the supremacy clause in the first place. Unfortunately, Big Fani is set on subjecting Mr. Meadows to criminal process in Georgia as quickly as without regard to his pending efforts in federal court. In addition to threatening an arrest on Friday, the state has also sought a scheduling order that would proceed exceptionally fast for a 19-defendant, 41-count prosecution. After the arrest, they want an arraignment on September 8th, Friday, and therefore they say time is of the essence. They're moving quickly. Judge, you've got to move quickly too. Now, if you don't grant a removal immediately to take this away from her, we ask the court now to issue an order to Fani to not arrest Meadows before the hearing on Monday. This short-term relief would prevent irreparable loss of his rights under federal law. Once they issue a warrant, it goes out into the system. It hits the system. You now have a failure to appear. Might suspend his license depending on where his license is and what the state does with it. But I mean, you got a warrant now. It's in Georgia, which I'm sure they're part of an interstate compact. And I don't practice law in Georgia or never did, but I would imagine they notify everybody else. And so it spirals out and hits the whole country. It's not good. And somebody who's got no criminal record doesn't want an arrest warrant for felonies and allow this court to consider the merit and then arrest him. Permit the removal. If you grant a simple extension, there's not going to be any substantial prejudice to Georgia. While federal courts will not enjoin pending proceedings lightly, a temporary pause here would not run afoul of the anti-injunction and anti-harassment statutes. This is going to protect federal interests flowing from the supremacy clause. They say, look, Mr. Meadows' grounds for removal here are very simple, but the case as a whole is complex. 19 defendants, 41 counts, 97-page indictment. This is going to take a lot of time, and state court proceedings are not stayed automatically as they would be with removal. Here, the state is threatening very quick arrests. We've got critical deadlines coming up and so on. They say, Your Honor, as we've noted, Mark Meadows, our client, enjoys legal immunity pursuant to the supremacy clause and federal removal statutes. If Meadows is required to defend himself in state criminal proceedings, he's going to suffer loss in the form of maybe his ability to raise his defenses at a later time. In either case, a brief temporary stay of these proceedings will preserve Meadows' rights without substantially harming Georgia. And they're telling us why it's likely he's going to win removal, and so we'll fast forward through some of this. A stay is not going to harm Big Fani. Therefore, the court should grant removal immediately and notify the state or issue an order prohibiting Big Fani from ordering the arrest. Signed August 22nd, respectfully submitted by John S. Moran. And so that's 17 pages, 19 of 19, submitted by Mark Meadows and his defense team. And we've talked about the policy behind this. Public's interest supports protecting the federal officers so the federal officers can do their jobs. We don't want state-level prosecutors to be able to pop their heads up like a jack-in-the-box and say, don't like that candidate, so we're going to just indict him. And so we see that is broken down. That is the emergency motion. Now, the judge issued an order saying that Big Fani had to respond to this, and so she did. But before we get there, this was the affidavit submitted by the attorney himself. So now he's submitting an affidavit. He's saying, Your Honor, look, I'm a partner at the law firm. I declare this to be true. Here's my exhibits. I got a copy of an emails from Big Fani, and she's not cooperating with us. These are all of my exhibits. We simply requested a very simple extension to the hearing on Monday. I declare this all to be true under penalty of perjury. And then Fani responds. So she just dropped this one, filed August 23rd, 13 pages long. She says the following. Mark Meadows, Your Honor, has made his motions, and now we are here responding to it. We're asking that the court dismiss or deny the emergency motion as is appropriate. Fani's team says, Your Honor, following a lengthy investigation, we issued an indictment for racketeering, and we know that we've got a removal hearing on the 28th. Following the indictment, Big Fani stated that she intended to provide the defendant, Mark Meadows, 2 weeks to voluntarily surrender. They requested the surrender date be postponed, quote, until next week. So Fani's saying, well, they didn't ask for just one more day. They just said next week, which you could say, okay, how about Monday, which is when we have the hearing. All right. So, but she put it in quotes for whatever reason. She says here, the defendant did not actually request a particular date in which to extend his surrender and only offers to confer after the evidentiary hearing set by this court on August 28th. Well, right, because at the hearing on the 28th, they're successful and the case is removed. Big Fani, your decision-making authority on this might change, right? He may not be responding to your deadline on the 28th anymore when the federal courts take it. Judge might decide to do something differently with it, maybe even dismiss the case. So he's saying, yeah, I'm not going to agree to show up at another hearing and self-surrender when I think my case is getting dismissed. But she's obviously perturbed about this. She's, did not actually request a particular date. All right. District Attorney denied the request, and then Meadows again requested that he be afforded additional time to request for it. Big Fani declined both. So then Mark Meadows, says Fani, filed this emergency motion and asked for an immediate removal or an order to stop the arrest. Accordingly, Georgia, the state, submits this response as ordered. They say, Your Honor, Mark Meadows' contention that the case should be removed on the papers is meritless. Pursuant to U.S. Code, the filing of a notice of removal shall not prevent the state court from proceeding. The only limitation imposed on the state court pending a notice of removal is that the state court may not enter a judgment of conviction before the prosecution is remanded. Additionally, if the district court does not order the summary remand, the court shall order an evidentiary hearing. And saying, accordingly, the court is required to conduct an evidentiary hearing, and the state is not precluded from proceeding against them, even though, so she's just saying we can go in parallel, Judge. You have your hearing, I'm allowed to do this while you're doing that. Saying that Meadows and his reliance on this case law is misplaced. Both of those were decided before the enactment of that statute. And so they're saying you can't rely on those cases to support your claim. Additionally, this court, in compliance with the law, has promptly ordered an evidentiary hearing when everybody can be heard. The court has also allowed the state until today to file a written response to the notice, and we're going to demonstrate in our filing that they're not entitled to any summary decision. And so the defendant and the request to remove the case is a not so subtle request to invite the court to stop the state from proceeding. Accordingly, it should all be denied. Mark Meadows requesting that Big Fani also be stopped from making the arrest violates long-standing principles requiring federal courts from abstaining in order to avoid the abstention doctrine. Meadows bears the burden of demonstrating that this was instituted in bad faith. And since he doesn't make those claims here, you can't stop us from conducting and issuing the warrant. In fact, federal courts have repeatedly denied requests to interfere in state cases, and they cite some cases. In essence, Meadows' emergency motion is a plea to the court to prevent Meadows from being arrested on the charges brought by Georgia. Despite his attempts to characterize this as a temporary pause, it is a request that the routine criminal processing be dictated by federal authorities. Here, the defendant does not allege that his prosecution is taken in bad faith, and there's no hope of obtaining a valid conviction. So in other words, Meadows is not pleading this appropriately to justify what he's asking for. His claim that his status as a former federal officer heightens this routine procedure is baseless. Even if Meadows were under federal jurisdiction, he would still be subject to arrest and detention. Other federal officers include former President of the United States have agreed to voluntarily surrender. So yeah, so Trump is saying, I'll show up, and Meadows is saying, but I don't need to show up. And she's saying, well, Trump is showing up, therefore Meadows should show up. That's not how that works. Additionally, Meadows' arrest will not preclude the defendant from asserting any state or federal defenses he may have. Just because one defense makes one claim doesn't mean all defenses have to take a certain strategy. People do different things all the time. They say Georgia criminal procedure provides that a law enforcement officer may arrest a person for a crime with or without a warrant. Generally, we issue warrants, and says Meadows' claim is meritless. Lawfully arresting a defendant on felony charges after allowing them time to negotiate their surrender doesn't impact him in any way. Okay, so she's basically just saying these things are entirely separate. I can do my arrest, you can decide your stuff, and he's got to deal with both of them at the same time. Even assuming that the court grants Meadows' motion to remove the case to federal court, prosecution still remains, and he's still subject to arrest for the offenses. Yeah, but that judge is in charge of all of this, not Big Fani's judge. Accordingly, the defendant's request to enjoin the DA should be denied. As they say in conclusion from Fani's office, U.S. Code requires the court to hold an evidentiary hearing on the removal, and Meadows' request that the court decide the issue immediately is incompatible with the statutory requirements. So Meadows wants it removed now, doesn't want to wait till Monday. She says there's no justification for now, you have to wait till Monday, and there is no justification for stopping me. They say further, Meadows has also failed to demonstrate any irreparable harm. This hardship facing the defendant is no different than any other defendants, and the Superior Court of Fulton has already issued an arrest warrant for the defendant, and this court is not authorized to enjoin such action pursuant. So I think Fani's just going to say the warrants have already been drafted, but just not entered, right? So the judge has already granted them, but they've given them time before those warrants go into effect. So Fani says, accordingly, this court should dismiss or deny the defendant's motion as appropriate. And this is going to be very curious to see what this judge does on this, because there's, Fani now is basically saying states' rights. Don't you dare, federal courts, come in here and try to interfere with our process. But she's also not adhering or agreeing with the federal court's hearing dates, basically saying it's, I'm going to schedule this when I schedule it. You didn't get it done fast fast enough. Now Meadows has to be subject to Fani's arrest, even though the case might be removed on Monday. I think the bigger question is going to be, what does Mark Meadows do? Does he, if the judge doesn't issue a ruling, well, we'll have to wait for a ruling. I'm going to guess he just follows the ruling. I don't think he'll get a warrant issued for him. So if the judge doesn't grant him something, I'm sure he'll show up, negotiate a consent bond, and they will push that thing through. But it's just been one thing after another over there. Big Fani is doing everything she can, including not cooperating with one-day extensions when Meadows is filing his claim in federal court. We'll see what the judge says about it. As we continue to cover, my friends, we will look forward to seeing you as you follow along. Thank you for subscribing, and we'll see you on the next one.